Hey everyone and welcome. Today we're getting into the kitchen, but not for food. We're going to be looking at a legal recipe. Specifically, the recipe for one of the most common legal claims there is, negligence.
Think about it for a second. You're walking through a store, you slip on a wet floor, or a car suddenly pulls out in front of you. It seems obvious someone's at fault, right? But how does the law actually decide who is legally on the hook for the damage?
Well, here's the thing. The law doesn't just look at who was being careless. To actually win a negligence claim, you have to prove a very specific set of ingredients, and you have to do it in the right order. If you mess up any part of this recipe, your whole case just falls apart.
So here's our game plan. We're going to follow that recipe step by step. We'll start with what negligence even is. Then we'll get into the 3 crucial ingredients you have to prove. We'll also see how a defendant might try to throw a wrench in the works. And finally, we'll talk about why this whole thing is such a delicate balancing act. So first up, what exactly is legal negligence?
Okay, so let's get on the same page. When we talk about legal negligence, we're not just talking about someone making a mistake or being clumsy. It's a formal legal idea, and it has a really specific structure.
The official term is the tort of negligence. Now, tort is just a fancy legal word for a civil wrong. The way to think about it is this. Criminal law is about actions against the whole of society. Tort law is about disputes between individuals, where one person's actions cause harm to another. And for this tort, the really key phrases are recoverable damage and legal duty. It's not enough to just be careless. You have to have owed a specific duty to the person who got hurt.
And that brings us right to our 3-ingredient recipe. To win your case, you have to prove all 3 of these. Number 1, that a legal duty of care existed in the first place. Number 2, that this duty was broken or breached. And number 3, that this breach is what actually caused the damage. Let's dig into each one.
So our first ingredient is the duty of care. You can think of this as the foundation of the entire claim. If you don't have this, the rest of the case just can't be built. It's like a gatekeeper that the law uses to decide which cases can even move forward.
What's so interesting is that this idea wasn't just invented overnight. It actually started way back in 1932 with a pretty simple neighbor principle. But, as society got more complicated, the courts had to keep updating the test to keep up. And eventually, in 2007, Singapore developed its own single unified approach. It's just a perfect example of how the law is never really static. It's always adapting.
And this is the quote that really kicked the whole thing off, the neighbor principle. Now, in law, your neighbor isn't just the person who lives next door. It's anyone you should reasonably expect might be affected by what you do. So if you're a car maker, your neighbor is literally everyone who drives your cars. If you own a coffee shop, your neighbor is every single customer. It's anyone you should have in mind.
So while all that history is super interesting, the main thing you need to know for today is that Singaporean law uses a single, unified test for all of these cases. And it's called the Spandeck test.
The Spandeck test really just boils it down to a 2-stage process. First, the court looks at something called proximity. Basically, is the relationship between the 2 people close enough? Then, if the answer is yes, they move to stage 2, policy. And this is a really important check. The court asks, okay, even if they're close, are there any bigger public policy reasons why we shouldn't impose a duty of care here? Like, would making police liable for every decision in a chaotic investigation actually make them less effective and harm the public? It's the law's final common sense check.
Okay, on to our second ingredient, breach of duty. Once you prove that a duty exists, you then have to prove that it was actually broken. This just means that the defendant's actions fell below the required standard of care.
So how do we measure that standard? Well, the law uses what's called an objective test, and it's based on the idea of a reasonable person. The court doesn't ask what the defendant, with all their own quirks and skills, thought was okay. No, it asks, what would a totally normal, reasonable, ordinary person have done in that exact same situation?
And here's where it gets really smart. This reasonable person isn't a one-size-fits-all kind of deal. A child is judged against what a reasonable child of that age would do. But if you're a professional, like a doctor or an engineer, the bar is set way higher. They aren't judged against an ordinary person on the street. They're judged against a reasonably competent professional in their own field.
For professionals, this standard is often figured out using something called the Bolam test. In a nutshell, it says that a doctor, for example, is not negligent if they can show that they followed a practice that a responsible group of other doctors would agree is proper. It's basically a standard that's set by their own peers.
All right, let's get to our third and final ingredient for the person making the claim, causation. See, it's not enough to show there was a duty and that it was broken.
You absolutely have to connect that breach directly to the harm that was suffered. This link is everything.
And the main test for this is actually pretty simple. It's called the but-for test. The court just asks one question. But for the defendant's action, would the harm have happened anyway? So let's say a doctor messes up a diagnosis for a fatal disease, but the evidence shows the patient would have died anyway even with a perfect diagnosis. Well, but for the doctor's mistake, the outcome is the same. Causation isn't proven.
But sometimes, another event happens after the first mistake. And that's where this concept of a novus actus interveniens, or a new intervening act, comes in. If a second event is so bizarre and unforeseeable that it breaks the chain of causation, the original defendant is off the hook. A classic example: you cause a tiny fender bender, the other driver gets out of their car and is immediately struck by lightning. That lightning strike is a novus actus interveniens. It's a completely new act that breaks the chain back to you.
The law also has another limit called remoteness. It's not just about causing damage. The type of damage has to have been reasonably foreseeable. So if I carelessly spill some water, it's foreseeable someone might slip and break their arm. What's probably not foreseeable is that the water shorts out a rare robot, causing a massive explosion. The kind of harm really matters.
So let's imagine the claimant has done it. They've successfully proven all three ingredients: duty, breach, and causation. Case closed, right? Well, not so fast. Now we have to look at the other side of the story, the defenses.
There are really three main ways to defend against one of these claims. First, there's consent, which is basically arguing the person knew the risks and did it anyway. Think extreme sports. Second is illegality, where you can't really sue for injuries you got while committing a crime. But the big one, the one that comes up all the time, is contributory negligence. This chart just gives you a rough idea of how often you see them.
Contributory negligence isn't an all-or-nothing defense. It's an argument that says, hey, the person who got hurt was also partly to blame. For example, maybe the driver was speeding, but the pedestrian crossed the street without looking. When that happens, a court can actually reduce the amount of money awarded. If both sides are found to be equally at fault, the damages can be cut right in half, by 50%.
So as you can probably tell by now, this is so much more than a simple formula. The law of negligence is this incredibly complex and fascinating balancing act. And it has to be, because it serves a really important purpose in society.
And that really brings us to the final, critical question at the heart of all this. All these rules, the duty of care, the reasonable person, causation, they're all just tools the law uses to find a balance. On one hand, you absolutely need to make sure that people who are genuinely hurt because someone else was careless get fair compensation. But on the other hand, if you make the rules too loose, you could open the floodgates to an endless wave of lawsuits that could paralyze everything. So the next time you see a wet floor sign, you'll know it's not just a sign. It's one small part of our society's constant effort to find that perfect and very tricky legal balance.